Okay, should be good. Hello, everyone. Thanks again for showing up to this. My name is TJ Van Osen. I'm the coordinator of the Philadelphia Reentry Coalition. I use he, him pronouns. It's great to have so many people here. We have like 50 people on. It speaks to how important the topic is. This is a training to provide like some context for the recent updates to the Ban the Box Ordinance in Philadelphia, and also the implications for it beyond the city, but primarily in Philadelphia. Ban the Box was updated at the end of 2020, and we're so grateful to have both Claudia and Brendan here from Public Interest Law Center and Community Legal Services. They spent a good chunk of time preparing this content and are really gracious to have taken the time to present all of this to you. So I'm really grateful for their time and their expertise, and without further ado, I'll turn it over to them.
Hi, everyone. Thanks so much for being here. I'm Claudia de Palma. I'm a staff attorney at the Public Interest Law Center. And Brendan and I are just going to walk you through Ban the Box today. As TJ said, there were amendments made at the end of 2020 that Community Legal Services, where Brendan is, was very involved in working on. So I'm going to just start with a basic reminder overview, just making sure everybody's on the same page. Much of this might be review for many of you, but just to get us all on the same page, I'll do a little intro, and then Brendan will give us the good stuff. So, all right. So I think the very first place to always start when you're thinking about criminal records and employment discrimination is what is on a criminal record. Just a reminder for everyone, it's created at the time of arrest. So someone can have a record even if they're not convicted of anything, simply because they were arrested. The arrest is one way that you might have what's called a non-conviction on your record. That includes any charges that were dismissed or withdrawn. And as many of you familiar with criminal records know, often when someone is convicted of something, there are several non-convictions that have been attached to that conviction. Of course, there are also convictions on a record. So those include plea agreements and guilty verdicts if someone went to trial. And there are other kinds of charges that often appear on a record and stay on a record, including ones that result from diversion programs and some juvenile adjudications. One thing to also remember, just when you're thinking about all of this, is that they're permanent unless an exception applies. For example, if you are eligible for an expungement, or if you are granted a pardon. And Brendan will talk about those options for cleaning up a record later on in this presentation. And so he'll talk about that more from the perspective of if you're helping someone with a record, what their options are. But it's just good to remember that unless otherwise applicable, a criminal record is created at the time of arrest, it's permanent, and unless it's subject to clean slate, which we'll also talk about, and something can be sealed, it's public. And so that is sort of your starting point for what you're dealing with when you're dealing with a criminal record. Also review for many, just to remember that when you're talking about charges, there are different categories and degrees of charges, and these start to matter when you're looking at things like what can be expunged, what can be sealed, et cetera. We have felonies, which are the most severe, serious category of offenses. Those are sometimes things like aggravated assault, many drug offenses or felony offenses, burglary, robbery. You have misdemeanors, which are lesser offenses, though still in some cases punishable by imprisonment. There's like the first degree misdemeanor, second degree misdemeanor, third degree misdemeanor, ungraded misdemeanor. And they can include any number of offenses, including assault, possession, some types of theft, retail theft. And then we have summary convictions. These are generally just punishable by a fine. They are the least serious. And they tend to be things like traffic citations or disorderly conduct, that kind of thing. Okay, so why did I go through all of this? When I talk about what's on a record and therefore what an employer might be seeing on a record, one really great evolution of that has been clean slate, which was a law passed in Pennsylvania a few years back that allows some of these records to be sealed, at least in part. So some charges of folks that you might be working with may, have been on their public record last year and are not there anymore, because some are being sealed automatically. So a lot of that non-conviction information that I talked about gets sealed automatically. Some summary offenses, some lower misdemeanors end up getting sealed if it's been long enough since the person had any sort of conviction on their record. And the rules for sealing are complicated, so it's very hard to look at any given charge or conviction on someone's record and know whether that can be sealed, because whether or not something can be sealed depends not just on the thing itself, but what else is on the record and how old the record is. And so again, Brendan will talk about that a little bit more if you have people you're working with who might be eligible and you're not sure how to sort of get into that process and have your record reviewed by someone who can actually tell you. But for purposes of me just sort of getting through the basics, it's just important to remember that what's on someone's record might not appear on their public record, but still be sort of on their file. Sealed charges as a default cannot be considered by employers or licensing agencies, meaning the record is still there if you're rearrested, if they can be pulled up on firearm permits. There are other situations in which these records come back up, but in general, the default should be that if you have a record that's sealed, an employer can't use it against you. So, ban the box. In Philadelphia, we're lucky to have a local ordinance that provides protections to people working in Philly. There are also federal protections, some, and a state law that protects people applying for jobs with records. But in Philadelphia, the sort of main go-to default law that applies is ban the box, which in some ways is the most protective of all three of those. And so we're lucky to have it. Ban the box does what it says it does, which is bans, that box on the application that asks if you've ever been arrested, convicted, however, many different ways that it's worded. Employers operating in Philly are not permitted to ask a question like that on an application. They are also not allowed to ask in an interview. In fact, you're not really allowed to bring it up at all until you can offer someone a job. And that job offer can be a conditional offer. As we'll get into, ban the box does permit employers to look at some records for some reasons. But the idea is you get off on the right foot. You get to be considered just like anyone else, basically on your merits, on your resume, on the way you're presenting in an interview. That's sort of a good way to remember, why the law is the way it is. Once employers put out a conditional offer, they are allowed to run a background check. So one sometimes misconception that I see when I work with clients is that they think no one is allowed to ask about a record at any point in the process. So ban the box does allow the employer to run a background check after a conditional offer is made. And then it protects those who do have records in a couple other ways. So once that background check comes back, ban the box prohibits employers from looking at convictions that are 7 or more years old. Another sort of common misunderstanding about that is that 7-year time frame, look back period, starts from either the conviction date or, if the person served time, the time of their release. So I had someone reach out a couple weeks ago saying, someone had a crime on their record from 1986 and now they were being denied a job. And when I followed up to ask whether this person had served time, he had been let out, been released, I think 4 years ago. And so that person is still within that 7-year look back period because it starts from release if you've served time. So If you're outside of that 7-year look back, as an applicant, the employer is not permitted to consider what's on the record. That's not to say it won't come up on the record. Another sort of thing to know is it might very certainly come up on your background check. It's just that the employer is just not allowed to consider it. If it's within that 7-year look back period, the employer is allowed to consider it, but Ban the Box prohibits that employer from sort of just automatically denying the person. Instead, it requires the employer to do what we consider an individualized determination. So the idea behind this, I like to talk about the ideas behind the laws because sometimes it's easier to remember them that way and to understand them. But the idea behind this is that a conviction should only be considered if it's going to be related to the person's ability to do the job. The only sort of allowable under the law, and this is true of state law as well, the only allowable reason to think about someone's record, to think about something that happened in their past, is if it would affect their eligibility, their suitability for the job. And so Ban the Box takes that principle and requires employers to make an individualized determination if someone has a more recent, within the 7-year look back period conviction. They have to think about some things that, you know, once you think about it, make a lot of sense, right? They have to think about, okay, well, what's the nature of this offense? Let's say it's a theft offense. Let's say this job does not involve any access to valuables. It doesn't involve access to money or handling any sort of property of the employer. That theft offense, even if it was recent, isn't really going to affect the person's ability to do the job. Time passed since offense is obviously always something to sort of point out if you're advocating for someone with a record, or if you're advocating for yourself, that the longer the time has passed and you've been okay, the less predictive it is that something like this is on your record. Obviously, again, this is true for any candidate. An employer is considering a worker's employment history, even in prison, before and after the offense, their skill set, their references, if they have character employment references, like how have they done in past jobs, maybe past jobs like this. Duties of the job sought is sort of similar to the nature of offense consideration, right? You're thinking about what, whether something in the job description is going to be affected by the conviction. And if it's not, then it's just irrelevant, or that's what I argue when I'm representing people who've been discriminated against. The employer's not allowed under the law to think they don't like the sound of what it says on this paper. It's really just a question of, like, does this affect the person's ability to do the job? Obviously, evidence of a rehabilitation is another thing that employers should and must consider for the same reason. You're really thinking about what is this person's ability to do the job now, rather than based on what happened in the past. And then finally, the sort of last bucket of things that Ban the Box helps with is that employers have to notify a worker if they are going to be denied a job because of their record. I think a lot of times outside of Philadelphia, before Ban the Box, what ends up happening is the person applies, the person does great, the person has a great interview, and then they ask for a bunch of paperwork, including a background check, and all of a sudden the person's ghosted. And I know that this has happened to many people, many of you have worked with, where you can't really say it's the background check, but you know that it's the background check, right? Because that was sort of the last piece to come in, or you know that the urine sample was clean, or you know that the references were great, and so you know that it's the background check, but the employer is never going to admit that. It can be useful to have this kind of requirement in the law, and we have it in the state law as well, to have a notification requirement where if you're going to do it, if you think you're within your right as an employer to do it, put it in writing, explain it, and then give the applicant an opportunity to address it. One thing we can't get into today because there isn't enough time is the fact that a lot of employers run third-party background checks. They use like credit reporting agencies to do it. And sometimes those records are wrong. They're not the right person. They are missing the sort of disposition information. It can be really hard to decipher them. And so having this opportunity to go back and look and figure out exactly what they think they read on the report can actually make a difference. So if all of this goes sideways, people have rights under the law to file a case. The first place that people go, and both I and Brendan have, Brendan's organizations have represented people in these cases, is at the Philadelphia Commission on Human Relations. They're the sort of first stop that you file a report, file a complaint with. And then if the Commission on Human Relations does not find that the employer acted wrongly, you can also go to a court after that. So there are, remedies including both injunctive, meaning like getting some sort of non-monetary relief, and damages, financial damages for violating this law. So I breezed through that because many of you, I think, probably know the basics, but this might be a good time to stop and answer any questions for things I breezed through too quickly.
There was actually a question in the chat, which is a pretty good question. If the employer essentially agrees that the conviction record will not affect the person's ability to do the job, but the employer's insurance company says that it's a risk, then what? Is that the same thing?
I think the answer has to be, unfortunately, that it depends. I know of situations where this has occurred. I think it depends on what the insurance company is saying it's a risk to. And I know that it gets, one of the places where this gets thorny is where something is being called a job qualification instead of, for example, like, let's say you need a permit to carry a firearm to do your job. Let's say that your conviction has no bearing on your ability to do the job itself, but because of federal firearm permit laws, you can't carry a gun, so therefore you're not qualified to do the job. So I've seen situations where an insurance company will come in and say, like, this person, because of this conviction, can't fulfill this essential duty and therefore is a risk. I think there you have a harder time sort of fighting that off. Brendan, do you have any thoughts on that question, that scenario? It's a hard one.
It is a hard one. I know for a fact that it definitely does happen. There's businesses carry liability insurance, and the insurers sometimes tell you can't have this person. There is no exception in the ordinance or in the state or federal laws that protect workers for insurance company concerns. That's not by itself an inherently valid reason to deny someone a job. If the employer, Claudia rightly points out, certainly sometimes the insurance company will be pointing to something that is legitimately, necessarily connected to the job. Other times they're just being overcautious. Over times they're just thinking, oh, it might look bad. Maybe they're thinking down the road and thinking, if this person ever did anything wrong and we got sued, it would look bad if we had somebody with a record. We don't want to take that chance. That's by itself where the record is not actually connected to the job. It's just having someone with a record might look bad in front of a jury or the media. That's not a valid reason. And if the insurance company, I think in many of those cases, is frankly pressuring the employer to break the law. And honestly, I think that the real answer in questions like that is a complaint to the state insurance department. That may sound silly. That may sound wildly off the ball, but I'm really serious. I think that in cases like that, and I'm certain this happens all the time, what I feel ought to happen is that the state insurance department ought to look at whether that insurance company is itself violating insurance regulations by requiring their insured parties to violate the law, because this is a case of discrimination. It's defined by the ordinance as an instance of discrimination when you keep someone out of a job based on a record that is not related to their ability to do the job. I realize that reentry referral folks have other things to do than file insurance department complaints, but it should happen. If you find yourself with the time to do it, if you find yourself with the wherewithal to encourage a disappointed client to file a complaint, please do. We should. So there are some other questions, and we do very much hope to have time at the end to get to questions. I think maybe I will try to pick it up and get through some of the slides about the ban the box amendments. I think I'm going to attempt to share my screen now, and let me see, here we go. Okay, so I'm gonna. Okay. We had several versions of this PowerPoint, and I'm terribly afraid I've pulled up the wrong version. But in any event, without further delay, so the new ban the box rules that go into effect on April 1st. There were several ways that ban the box did not, that had loopholes and gaps that failed to protect Philadelphia workers. And so one of the most important is that it was written so as only to apply to applicants and not to current employees. And many people were finding that new management would come in, or a new background check would be done, perhaps through a different third-party background checker that would pull up things that hadn't been caught before, or the company might just be bought out by a competitor. In any event, someone who had been working at the job for a while and had demonstrated by their very employment that they were indeed able to do the job without incident would discover that their background was rechecked and they were let go. And the ban the box as written used to not protect them. Now, starting April 1st, it will clearly apply both to job applicants and also to current employees. And there will be, as written, the same, in effect, the same rules, the same procedures will be required. If you are reviewing it in order to, because you're considering whether to retain them, you know, if it's part of if you're in some field where it's a state mandated background check that has to be done once a year, you are in effect making a determination about whether to retain that person. And of course, it would also apply if you were running a background to consider them for a promotion or something of that sort. You still need to make a conditional offer, in effect, of whatever you would be offered, whatever job action is at stake. You again can only rescind it if the record was in 7 years, and you again need to consider all the factors that Claudia referred to, and the fact that you have been at the job and successfully performing the job is itself must be required and must weigh in your favor. And so it ought to be that it should be even less likely that it would be turned down for either retention or promotion after you've had the job as a current employee than even as an applicant. And so hopefully that will protect substantially more people than were technically protected in the past. There's also an updated definition of employer. It was, I think, possible to read the ordinance as applying to a variety of gig economy employers, Uber and Lyft. There's often a question of whether it applies to Uber and Lyft, and to the many other gig economy companies that have just come into existence in very recent years. It was also not clear, I think, if it provided to people that did referrals. There's this online website called care.com that tries to refer people to healthcare jobs. And sometimes these platforms were in effect cutting people off from employment by making a determination that they would not qualify for some third party and therefore they would not be referred. The definition of employer has been expanded to explicitly include and the definition of employee and the definition of who the law applies to has been explicitly expanded to state clearly that it applies to gig workers, it applies to independent contractors, it applies to people placed in employment by online employment connectors and facilitators. And I think the idea is that if someone, whether they are the ultimate employer or not, whether they are the ones who are ultimately paying your wages or not, if they are making a decision about whether or not you can have work, whether if they are reviewing your criminal record and making a judgment about your employability, they have to follow the ban the box rules when they do that. And so if for employment referral agencies, it is not going to be appropriate to decline to refer to someone because you suspect that the employer on the other end won't want to hire that person. If you suspect that the employer on the other end is going to break the law, as a job referral agency, you are going to need to go ahead and let them break the law. You are going to need to refer that person. And if there's going to be a complaint, the complaint hopefully will only be against the employer that actually refuses to abide by ban the box. And so this should greatly expand the number of people who are protected by this. And again, the ban the box applies to employment in Philadelphia, work done by people in Philadelphia. It doesn't apply to Philly residents. You can live anywhere as long as you're working in Philly. And I would say that job referral that is performed in Philadelphia would also be covered by the law. So people who are potentially referring workers to jobs in the suburbs, there again, if you are reviewing someone's record and making a judgment about whether you can and should refer them for work, you should be following ban the box rules. Ban the box applies to all companies with one or more employees. There are also rules about pending charges. I think this is something that employers had sought, and just so people are aware, it certainly does happen that someone is arrested or charged, is hit with brand new charges, and I think employers had wondered, can they ask about that? The new rules try to say you can ask first of all, if you get some solid information one way or another, some word of mouth from an employee or some other way, that someone has pending charges that are actually relevant to the job, you can ask about those. You can also have a policy that requires employees to report pending charges. Many employers do have something like that. But there has to be a written policy. It has to be clear what people can expect and what rules they will need to abide by in terms of reporting any arrests that come along. And there, as with promotions, as with retentions, as with new hires, you cannot take adverse action. You can't fire someone or suspend them based on a pending charge without doing the same individualized assessment as you would do for convictions. Obviously, the age of the offense is going to be much more recent for a pending charge than for a conviction from 1986. But at the same time, the person has not been convicted, and whatever they're charged with, again, may not relate to the duties of the job. And so employees will be, as of April 1st, required to take that into account if they are inquiring about pending charges. There was a question that we thought might be relevant for this group about what if someone is coming from a reentry program. Reentry programs obviously will typically be working with people who, by definition, have a criminal record. So there will be some sense in which many employers will inherently be aware that the person coming to them has something on their record. What can they ask about? What is appropriate for an employer to ask in that situation? And the box is written to give the power to the worker to decide whether or not to divulge their record and talk about their record prior to getting a conditional offer. So they can certainly decide to divulge it, and the law explicitly says that employers can ask about it if it is divulged. But the way the law is written, the way that I read it, I think it's fairly clear that employers do not have the automatic right to instantly start the job interview by delving into the person's background if they haven't voluntarily divulged it. That may make the most sense in a given situation. Workers don't always have to object if they sense that an employer is sympathetic and they want to start off on the right foot. But they don't have to allow that. It is technically a violation of the law if employers push and insist on inquiring about someone's record prior to a conditional offer of employment if the worker has not voluntarily divulged it. I do think that workers do have the ability to alert their referral agencies if this is going to come up in a given situation. Could they say to the reentry program, oh yeah, go ahead and tell them, I know they're going to find out, because as Claudia mentioned, they are going to find out. They can and will do a background check after the conditional offer, and if the worker feels it's appropriate, they have the option to give people the record, the ability to divulge it, and they can divulge it themselves. But the choice is supposed to rest with them.
And Brendan, let me just interject for just 1 second, because a question came up in the chat that I think would be good to address now. If they do divulge, are they still protected by the other elements of the law? So for example, are they still entitled to a individualized determination? If the record was older than 7 years, are they still protected by that 7-year look back period?
Yes, that's a good question. And the answer is absolutely yes. 100%. You definitely are protected by all the other elements. The right to receive a copy of the record, the right to receive a reasonable period of time to dispute the record if there's anything wrong with it. Yes, all of those protections definitely still apply. The reason for the conditional offer, the reason for the requirement of a conditional offer, of course, was to make it clear why someone was being turned down, because there's a long-standing pattern. Probably every single person on this presentation is aware that people will reveal their records, divulge their records. The employer will learn about it, and then there's just radio silence and communication stops, and they never hear back. And the worker says, it was because of my record, wasn't it? And they can never get an answer, and it's hard to prove. This is supposed to make it clear what's going on, what we all frankly know often goes on. So, you know, certainly employers who learn about your record and then ghost you are trying to get around a legal requirement that they, in effect, make it clear the reason why they are not giving you the job. If you're coming from a referral program, you are still owed that same consideration. And all the rights in the law are there still to protect you. And people who are referred from a reentry program and still nevertheless denied the job, even if there was no conditional offer, or even if there was a discussion beforehand and then a ghosting prior to any conditional offer being made, I would encourage those folks still to go ahead and make a complaint to the Philadelphia Commission. I think it's equally clear what's going on when someone has been referred from a reentry program. We know that there's a record, and then there was the employer learned about the record, and then the person didn't get the job. It's not hard to imagine what's going on, and the Philadelphia Commission absolutely can and does handle complaints like that. So I wanted to briefly say that, as Claudia mentioned earlier, of course, as most of you probably know, there certainly are other requirements. Certainly state law and federal law trump local law. So there certainly are many statutes, Pennsylvania state and federal statutes that govern various professions. And those laws absolutely still apply. Pennsylvania law, Philadelphia law cannot override those laws. To the extent that employers can apply both of them, can abide by ban the box and also comply with the criminal records restrictions of a given statute, they have to. They do both apply to the extent that they don't contradict each other. So, for example, there are in some fields there are laws that say, employers shall not hire people with these given records. But the law doesn't say that employers have to ask that at the outset of the employment process. It doesn't say, there's nothing about whether they have to inquire or research the person's record prior to making a conditional offer. There will be many situations in which employers can do both. They can make a conditional offer and then proceed to apply whatever restrictions are set out in state or federal law. The ordinance, by the way, does say that to the extent you want to let people know, it is permissible to put a notice in job applications as that you will be doing, that people will have to pass a background check, which sometimes is very valuable for them to know, but it has to be made clear that they will be given fair consideration, not automatically turned away. The job listings, which I've seen many of these, I think I see them on Craigslist, I think I've seen them in other places, simply saying, you know, must have clean criminal background, must have no criminal background. That's a straightforward violation of ban the box. You can't say that. You may be able to say there are, you know, limitations on people with certain convictions, but people will be given a fair opportunity to explain that they qualify for this job. Something to that effect might be okay, but not something that's intended to deter people from working. I just wanted to say a little bit about some of the things that people should know about how records can be cleaned up. Hopefully, there will be opportunities for most of the people listening to refer folks either to my organization, to Public Interest Law Center, to Philadelphia Lawyers Social Equity. There are even some of the law school clinics that are working on clearing up records in various ways. It's very sad, we find, when people qualify to have their record cleaned up and they don't take advantage of it. And that was part of the impetus for Clean Slate, was actually finding that very many people qualified to have their record expunged and were not taking advantage of it. So people ought to know. We want to get the word out, and we want people to be aware of their options. So expungement is certainly the best way to clear up your record. Because it removes it from all versions of the record. You can file a petition in court. The court can order that the record be expunged, and it applies. You can qualify for an expungement in various situations, including if the charges were dropped or dismissed, if you were found not guilty, if there was a pretrial diversion program such as ARD or Section 17, and you successfully completed that. If you were convicted of a summary, but you've been arrest-free for at least 5 years. Juvenile adjudications, which can be very complicated, but you can get those if they are still showing up in your adult record. There are sometimes ways to get them off. And there's also a provision for folks who are over the age of 70, have been free from arrest for at least 10 years. That's basically the only way that an expungement can get a felony conviction off of your record, is with the over 70 provision, unless you get a pardon. Here's pardons. So a pardon, it takes much longer than an expungement. I need to edit this slide. The Board of Pardons never says exactly. There is no explicit official timeline for getting a pardon. It's whenever they get around to it, and then whenever the governor signs it. In fact, the Board of Pardons recently, I think next week, is maybe scheduled to have a hearing for a client of mine who filed just 2 years ago. So that's been a dramatically faster improvement, but only very recently has it gotten that fast. For a long time, it was typically 4 years. A pardon can be any state offense. Of course, for a federal offense, you'd have to apply to the president. And this is, again, for people under the age of 70, this is essentially the only way to get a felony removed from your record is with a pardon. And people, so the longer it's been since you've had a conviction, and the more minor the convictions, the better candidate you are to receive a pardon. People do get pardoned for felonies. It definitely does happen. Certainly, if someone has a 30-year-old felony and no conviction since then, I would urge them to work on a pardon immediately. They are a very strong candidate and very likely to be granted one if it's been, 2 or 3 decades and they have no record since that time. And the law has just changed so that getting a pardon will now automatically result in the conviction being sealed on your record. You won't even have to go to file a petition in court asking them to seal it. It'll happen automatically. Fines and costs are a problem that affect many people because many people don't realize that they owe them. They often linger on people's records and people don't get notices or reminders. You can now apply for sealing even if you owe most court costs, but you can't get sealing if you still owe restitution. and basically owing if you want to completely remove it from your record, which you can do with a pardon. Again, it's sort of automatically sealed, but if you want to get it expunged, you can file a petition to do that, and you automatically qualify for full expungement if you do get a pardon. But you probably won't get a pardon if you owe any court costs at all. And if you're not if you haven't been current on a payment plan, the costs will often be sent to collections, and you'll owe a collection fee on top of the fees themselves. So we encourage people to address these. People don't have to simply accept them. There are petitions to request the waiver of some fees. Often the biggest single item on many people's criminal records is, it'll say, in most versions that I see, it says OSP, which is an abbreviation. It basically stands for supervised probation. People have to pay like $25 per month. Every month they're on supervised probation, and that adds up very quickly, and people often owe hundreds of dollars based on that. You can have that way. The court doesn't have to, but the court has discretion to waive payment of those fees, and that can dramatically reduce the overall court costs that people owe. So we strongly encourage people to think about filing a motion to reduce or waive supervision fees, which can be filed in court, and you can get a hearing in a couple of months, and that can put people in much better position to get a pardon. We're running pretty long, so I don't want to give all the details about court fines and costs. If people have questions, that they're welcome to review these slides later. They're welcome to contact me. We're happy to pass this information along. And needless to say, CLS is here, and we're happy to try to assist individual people to the extent that we have the capacity to. We are sometimes able to file petitions for folks and go with them to court.
Brendan, one question that's come up that seems good to ask now is, besides filing motions to waive, are there any initiatives that you guys are aware of to address or remove fines and costs on someone's record?
The ACLU of Pennsylvania actually has a project that's working on the burden of court costs, and they have been trying to advocate for and innovate some ways to help people challenge outstanding court costs, which is terrific. It can vary a lot depending upon the type of court cost and how it came about, but there are sometimes other types of petitions that can be filed. People ought to, for many types of court costs, people are supposed to have had a chance to show that they're unable to pay them before being ordered to pay them, and sometimes that step gets skipped. So if that never happened, and if you are now currently unable to pay them, there may be things aside from supervision fees. Supervision fees, it's very clear in the law that you can file for that. Other things that sort of somewhat less clear, but people do have the option to do it. And there are situations and certain types of court costs where you can petition the court to let you do community service instead of paying the fines. It gets very complicated. I'm not an expert on all the many different types of fines, but if that is a barrier for people, we encourage them not to give up. We encourage them to look into it, possibly to come to us. We may be able to advise them, help them, or send them in the right direction. And people have the right to file pro se petitions. It doesn't always work, but this is America. That's one right we still have. People they like getting things on their official forms over in the criminal court. But if you think something's wrong, if you think you've been ordered to pay something you can't afford, people have the right to file a petition in court and say, hey, somebody should remove this from my record, and it ought to work, even if it might often not. So I think that was the final slide. Are we just going to go to questions?
Maybe I will start going down the list, but please feel free to continue typing some in. Let's see here. So one question that is a good one. They're all good. One question that I should have addressed more clearly in my initial sort of introduction about clean slate is, so the effect of getting a record sealed is a court order, and that court order in effect seals that record in like the official sort of database. And then to the extent that someone is an employer using like a third party like Verifact or backgroundcheck.com or whatever, to the extent that they're using one of these, we call them CRAs, credit reporting agencies, those credit reporting agencies are supposed to be updating their database. And there are provisions in the law, the Clean Slate law, that like requires the state to make sure that they're giving the data, like updating the data and making sure that these credit reporting agencies have what they need in order to make up-to-date, accurate reports. CRAs are, some of them at least, are pretty notorious for using stale data and for reporting things that should be sealed, should have been expunged, should have been, were pardoned. And so that's one important thing to look at when someone comes back with a background check and there's something on there that shouldn't be. It's often the result of the credit reporting agency not updating their database. But regardless of whether you're getting that record from UJS or from Verifact, it should be sealed. The exception to the sealing thing is FBI background checks will have sealed records on them. Let's see. Brendan, you can see these questions now, so feel free to pull one.
A company that has locations nationwide, does ban the box apply to their Philadelphia location? Yes, absolutely. They may not want it to, and they may feel that it creates some complications having to set out different policies for different locations, but many national corporations do just that. As a matter of fact, it's pretty, as much as they may whine about it, it's actually standard for different states to have different criminal laws, different employment laws. So any national corporation has no choice but to adjust its practices to the laws of the jurisdiction where it works. And the laws in Philadelphia apply to Philadelphia, residents and entities. So yes, frustrating as it may be, as much as they may not want to have to deal with it, ban the box definitely applies to companies with locations nationwide in their Philadelphia locations. Does the criminal record in this ordinance include allegations on the child abuse registry? No. I think there's an excellent argument that the principles set out here ought to, but that's a different ball of wax, of course. In theory, allegations of the child abuse registry are only available in a limited number of circumstances to a limited number of employers, or I guess it also applies to volunteer opportunities. And the conditions under which it can be used are set out in the Child Protective Services Law, which frankly needs to be rewritten. And but no, as written, I would not say that the ban the box ordinance governs the use of allegations in the child abuse registry. I don't have a copy or an example of a policy for pending charges. It might be nice to have one. I think every so often the Commission on Human Relations maybe has put out some models for people to draw on. I haven't looked for that, so I don't know for sure if they have one of those. As to whether if the umbrella of the law is gone, if a person discloses the record during an interview. My reading of the ordinance is that the protections for the worker and the requirements for the employer, including the looking at the conditions and the 7-year limited look back, giving a copy of the record, that those are not explicitly tied to whether or not a conditional offer was made. I mean, they're set out as the conditional offers requirement, and the protections and other requirements are also in addition equally required. So I I would not take it that violating one part of the law in effect obviates the application of the other parts of the law. It's certainly true that if you voluntarily disclose, you cannot then turn around and make a complaint for them inquiring about your record. So that limited aspect of the ordinance, I think, no longer applies if you voluntarily disclose. But the rest of the ordinance, I take it still applies. That would be my interpretation.
That's mine as well. If we missed someone's question and they want to retype it in, I think we have a couple more minutes.
Are there initiatives to address, remove, alleviate fines and court costs?
Yeah, that's what I asked you while you were.
Yeah. So again, the ACLU has been working on this, which I'm very heartened by, and I salute them for that. I think it might take the effect of pushing the state to stop piling so many fines and costs on people. There used to be just a few individual lines on the financial information, and now it's a full page of different little fines and costs that you owe for almost any conviction, and they pile up left and right. It would be nice to get some of those waived. It would be nice to have more universal adherence to the idea that people should get a hearing on their ability to pay. But beyond that, I'm not sure I know of a large-scale movement to rescind those. The courts really have come to rely on getting funded by many of those costs, unfortunately. Toby Oxholm, who has done outstanding work at Philadelphia Lawyer for Social Equity for a number of years now, notes something that I had heard very recently, but I wasn't, Toby, I'm certain exactly how much we can count on this. I heard very recently that the board has taken less concern for court costs and fees. They may more concerned with restitution that people have been ordered to pay, and fines if those are unpaid, but that the court costs and fees they may be willing to overlook. That is certainly a change from their past practice. For years and years, they were insistent that you had to have paid them all off. And I just, I have heard that they're de-emphasizing that, which is great. They should. It's not clear to me from my seat how much we can count on them to stick to that in the future. And there's also the governor's office. The way pardons work is that you apply to the Board of Pardons, you get a hearing in front of the Board of Pardons votes on whether to recommend a pardon, then it goes over to the governor. The governor can do whatever the governor wants. The governor could sign it that same afternoon. The governor could wait a year and a half. The governor could deny it. So just because the board decides to de-emphasize something does not automatically mean that the governor will see things the same way. So I think that the way that the board has handled fines and costs has changed over the years. I think there have been cases in which they have recommended a conditional pardon, which is something they have the power to do, conditioned on somebody finishing the payment of court costs that they owe. That's great. I hope they stick with that. If I were advising someone starting out in their pardon process today, I would certainly urge them to, if at all possible, get all of their fines and costs taken care of, either of petitions to the court to have them waived or reduced, or to do community service in lieu of fines that they may owe, or to enter in a payment plan to pay off whatever remaining things they're not able to get waived or reduced. But I think Toby is right to point out, I wouldn't necessarily, if there were some lingering costs, I wouldn't use that as a reason not to file for the pardon. Pardon can be life-changing, and if there's a chance you can get it, and if you can show good faith that you've been trying to pay off what you're able to, if you're otherwise a strong candidate for a pardon, I don't think I would let that stop you from applying for the pardon. Go Supreme Court Rules Committees. That's awesome. Toby points out, and Toby Oxfam of Pulse points out in the chat that there are efforts underway and proposals to possibly waive court costs and fees, and that is very heartening to hear. And you know, if people ever have a chance to weigh in, please weigh in and say, "Yep, that is what needs to happen."
And it seems like that's the end of the questions. So we're right at time, and I'll just say again, thanks so much to both of you, Claudia and Brendan, for taking the time. This was really helpful for me, and it seems like a lot of people are thanking you in the chat as well. So